Hey y'all, this is going to be part 3D, the undue burden standard. So basically, in the early 90s, the court changed from the tripartite or trimester framework to what's called the undue burden standard. And this started in our first case, Planned Parenthood v. Casey in 1992. It is a 5-4 part affirmation, part reversal, and Justice O'Connor, Kennedy, and Souter all deliver the majority opinion. So first, they reaffirm the basis of Roe, and say that women have a right to an abortion, especially pre-viability, um, and that the state can basically make no regulations during the first trimester. Um, Regulations designed to protect the woman's health, but not to further the state's interest in life are allowed in the second trimester, and then prohibitions are permitted for the life of the child or when the health or life of the mother is at stake in the third trimester. And so they go on and say that we are completely getting rid of the trimester framework. And in lieu of that, what we're going to add is the undue burden standard. Um, and they basically say a finding of an undue burden is a shorthand for the conclusion that a state regulation has the purpose or effect of placing an obstacle in the path of a woman seeking an abortion of a non viable fetus. So again, they still add this viability test. A statute with this purpose is invalid because the means chosen by the state to further the interest in life must be calculated to inform the woman's free choice, not hinder it. And a statute which, while furthering the interest in potential life or some other valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice, cannot be considered a permissible means of serving its legitimate ends. Um, we reject the rigid trimester framework of Roe. To promote the state's interest in potential life throughout pregnancy, the state may take measures to ensure that the woman's choice is informed. Measures designed to advance this interest should not be invalidated if their purpose is to persuade the woman to choose childbirth over abortion. These measures must not be an undue burden on the right. So basically, they're saying that while the state cannot um, basically burden a woman's choice to abortion pre-viability, they can sort of try to persuade you not to get an abortion and to provide information about either adoption or family planning or that sort of thing rather than abortion pre-viability. As we have stated, under the undue burden standard, a state is permitted to enact persuasive measures which favor childbirth over abortion, even if those measures do not further a health interest. Okay. And then they go on to talk about three rules that I think this is a Pennsylvania case. Three rules basically that Pennsylvania had enacted. The first is about spousal notification pre-abortion. The second is about parental notification pre-abortion, and the third is about clinical record keeping. Okay, about spousal notification, they say. The spousal notification requirement is thus likely to prevent a significant number of women from obtaining an abortion. It does not merely make abortions a little more difficult or expensive to obtain. For many women, it will impose a substantial obstacle. We must not blind ourselves to the fact that the significant number of women who fear for their safety and the safety of their children are likely to be deterred from procuring an abortion as surely as if the Commonwealth had outlawed abortion in all cases. The husband's interest in the life of the child his wife is carrying does not permit the state to empower him with this troubling degree of authority over his wife. So Pennsylvania cannot enforce their spousal notification program. Two, parental notification. Our cases establish, and we reaffirm today, that a state may require a minor seeking an abortion to obtain the consent of a parent or guardian, provided that there is an adequate judicial bypass procedure. Under these precedents, just as we talked about in the former section, in our view, the one parent consent requirement and judicial bypass procedure are constitutional. And then finally, clinical record keeping. They basically say that, like, requiring clinics to keep records on who manages them and where they're located and how many abortions they provide in which trimesters is not a substantial burden. So the state can also require that. So basically, they only strike down the spousal notification. Okay, case two, Mazurek v. Armstrong. This is 1997. This is a per curiam decision, so basically nobody puts their name on it. In 1995, Montana passes a law restricting the performance of abortion to licensed physicians rather than like physician's assistants or nurses. And they say that's fine. In the course of upholding the physician only requirement at issue in that case, we emphasize that our case reflects the fact that the Constitution gives the states broad latitude to decide that particular functions may be performed only by licensed professionals, even if an objective assessment might suggest that those same tasks could be performed by others. So, the states have licensure rules and they're in charge of that. Okay, case three. Whole Women's Health v. Hellerstedt. This is 2016, so this is much later, much more modern. It's a 5-3 reversal, and Justice Breyer delivers the majority opinion. And at this point, like we were talking about in the last, one of the last lectures, um, abortion is legal, but states are trying as hard as they can to make abortion clinics as expensive or as staff heavy or as restrictive as they possibly can to try and close down as many abortion clinics as they can, especially in the South. And so Texas has these new rules, two rules: admitting privileges requirements and surgical center requirements. Okay. Um, First, the admitting privileges requirement. A doctor performing or inducing an abortion must, um, it says or, I spelled it wrong. A doctor performing or inducing an abortion must, on the date the abortion is performed or induced, have acting admitting privileges at a hospital that is located not further than 30 miles from the location at which the abortion is performed. So you have to be a surgical doctor who has admitting privileges on the day that you perform an abortion, and it has to be within 30 geographical miles of that particular hospital. Requirement two, the surgical center requirement. The law says the minimum standards for an abortion facility must be equivalent to the minimum standards adopted under the Texas Health and Safety Code for ambulatory surgical centers. So this meant that you had to have massive facilities with huge operating rooms that were built in a very particular way. And you had to have, particular staff on file, like a cardiologist, which really isn't necessary for for an abortion, or for the vast majority of abortions. And so the idea here was to just make these so onerous that abortion clinics couldn't do it. And basically half of all abortion clinics in Texas closed down as soon as that law went into effect. And so we come to the ruling. The ruling says we conclude that neither of these provisions confers medical benefits sufficient to justify the burdens upon access that each imposes. Each places a substantial obstacle in the path of women seeking a pre-viability abortion. Each constitutes an undue burden on abortion access, and each violates the federal constitution. First, admitting privileges. We add that when directly asked at oral argument whether Texas knew of a single instance in which the new admitting requirements would have helped even a single woman obtain better treatment in some way, Texas admitted that there was no evidence in the record of such a case. However, it does cause a substantial burden. It led to the closing of half of all of the clinics in Texas. And Texas is a huge geographic area, right? And so we went from about 40 to about 20. In our view, the record contains sufficient evidence that the admitting privileges requirement led to the closure of half of Texas's clinics or thereabouts. Those closures meant fewer doctors, longer waiting times, and increased crowding. Okay, so that's unconstitutional. Second, the surgical center requirements. There is considerable evidence in the record supporting the district court's findings, indicating that the statutory provision requiring all abortion facilities to meet all surgical center standards does not benefit patients and is not necessary. Moreover, many surgical center requirements are inappropriate as applied to surgical abortion. Abortions typically involve either the administration of medicines or procedures performed through the natural opening of the birth canal, the vagina, which itself is not sterile. More fundamentally, in the face of no threat to women's health, Texas seeks to force women to travel long distances to get abortions in cram to capacity super facilities. Patients seeking these services are less likely to get the kind of individualized attention, serious conversation, and emotional support that doctors at less taxed facilities may have offered. Healthcare facilities and medical professionals are not fungible commodities. Surgical centers attempting to accommodate sudden, vastly increased demand may find that quality of care declines. Another common sense inference that the district court made is that these effects would be harmful to, not supportive of, women's health. And so both of these are inviolated. Okay, case 4, June Medical Services v. Russo in 2020. They just say, we consider the constitutionality of a Louisiana Act, Act 620, that is almost word for word identical to Texas's admitting privileges laws, so we strike it down. Okay, case 5, Dobbs v. Jackson Women's Health Organization, one of the most controversial decisions since Roe v. Wade. This was a 6-3 reversal along conservative liberal lines, right? And Justice Alito delivers the majority opinion. And here's how it goes. Mississippi wanted to uphold a 15-week abortion ban several weeks before the court's viability threshold. And this is a big one, so we're going to read a lot of it. First, they say, we hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be, quote, deeply rooted in this nation's history and tradition, and implicit in the concept of ordered liberty. The right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right this court has held to fall within the 14th Amendment's protection of, quote, liberty. Roe's defenders characterize the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions call fetal life, and what the law now before us describes as an unborn human being. So they're completely turning it off, and they're basically remanding the decision back to the states. And Justice Thomas gives a very concerning concurrence with this that a lot of people are very, very worried about. And he says there's another reason why the 14th Amendment and due process doesn't cover abortion. And he basically says it's because the due process clause is bullshit, that it is a made up thing. And he says that we need to go back and look at multiple due process rulings, including Griswold v. Connecticut in 1965, that gives the right of married persons and others the right to obtain contraceptives. So he's calling that into question, whether women should even have the right to obtain a contraceptive. 2. Lawrence v. Texas in 2003, the right to engage in private, consensual homosexual acts in the privacy of your own home. The 2003, the court ruled that the state has no abiding interest whatsoever in determining what kind of sex people were having behind closed doors. But Justice Clarence Thomas says we need to look at this again. And then finally, Obergefell v. Hodges in 2015, which gave gays and lesbians the right to marry. He says that should be overturned as well. And he goes on to say, for that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell, because any substantive due process decision is, quote, demonstrably erroneous. We have a duty to correct the error established in these precedents. So he's saying, like, bring these cases to me, I will overturn them. So very worrisome stuff in many people's opinion. Okay, and then Breyer, Sotomayor, and Kagan offer a huge dissent. They say, today the court discards the balance. It says that from the very moment of fertilization, a woman has no rights to speak of. A state can force her to bring a pregnancy to term, even at the steepest personal and familial costs. States may even argue that a prohibition on abortion need make no provision for protecting a woman from risk of death or physical injury. Across a vast array of circumstances, a state will be able to impose its moral choice on a woman and coerce her to give birth to a child. After this decision, some states may block women from traveling out of state to obtain abortions, or even from receiving abortion medications from out of state. Some may criminalize efforts, including the provision of information or funding to help women gain access to other states' abortion services. Most threatening of all, no language in today's decision stops the federal government from prohibiting abortions nationwide, once again, from the moment of conception and without exceptions for rape or incest. If that happens, the views of an individual state citizens will no longer matter. Whatever the exact scope of the coming laws, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens. And no one should be confident that this majority is done with its work. The right Roe and Casey recognize does not stand alone. To the contrary, the court has linked it for decades to other settled freedoms involving bodily integrity, familial relationships, and procreation. Most obviously, the right to terminate a pregnancy arose straight out of the right to purchase and use contraceptives. In turn, those rights led more recently to rights of same-sex intimacy and marriage. See Lawrence v. Texas and Obergefell v. Hodges. They are all part of the same constitutional fabric, protecting autonomous decision-making over the most personal of life decisions. And then they conclude, so one of two things must be true. Either the majority does not really believe in its own reasoning, or, if it does, all rights that have no history stretching back to the middle 19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under severe threat. It is one or the other. So, yeah, I'll leave you there. I'll see you for the next one, The Right to Die. Have a great day.